Hello everyone, this is Polity and Governance, May 2023 with an IS current affair. Okay, so let's complete it. Quick reading, very quick reading. National Capital Territory of Delhi Ordinance 2023 Central Government issued the Government of National Capital of Delhi Ordinance, Government of National Capital Territory of Delhi Ordinance 2023 which seeks to amend the GNCD 1991. 2023 Supreme Court verdict by quoting the Article 239AA. 239AA Supreme Court that the elected government of the National Capital Territory of Delhi has some legislative as well as the executive power over the service under the entry 41 list 2 of 7 schedule. Union government is bound by the aid and advice of the COM, Council of Ministers of the National Capital Territory in relation to the matters within the legislative scope of the National Capital Territory of Delhi. Now, it is an ordinance. It nullifies the effect of the recent Supreme Court's decision that gave the Delhi government powers over the administrative service, excluding public order, police, and land in the National Capital Territory. Article 239AA was inserted by the 69th Amendment Act of 1991, which conferred special status on Delhi on recommendation of the S. Balakrishna Committee. It provides that NCT of Delhi will have the administrator and a legislative assembly. The legislative assembly shall have the power to make laws and with respect to any matters in the state list or the Congress list, except for the subject of the police, land, and order. In case of the difference of the opinion between the LG and its ministers, LG shall refer to it to the president. Key highlights of the ordinance is power to legislate over the service. Legislate over service. Ordinance specifies that the Delhi Legislative Assembly will not have the power to legislate on the subject of the service which come under the state list. Services include matters related to appointment, transfer of employees of the Delhi government, and the vigilance. Now, services include the matters related to appointment, transfer of employees of the Delhi government, and the vigilance. National Capital Civil Service Authority. It creates a new statutory authority, National Capital Civil Service Authority, to make recommendation to lieutenant governors regarding the transfer, posting, vigilance, and other incidental matters. National Capital Civil Service Authority will consist of a CIS. National Capital Civil Service Authority. It creates a new statutory authority, National Capital Civil Service Authority, to make recommendation to lieutenant governor regarding the transfer, posting, vigilance, and other incidental matters. National Capital Civil Service creates a new statutory authority, National Capital Civil Service Authority, to make recommendation to the Lieutenant Governor regarding the transfer, posting, vigilance, and other incidental matters. National Capital Civil Service Authority will consist of a Chief Minister of Delhi, who shall be the chairperson of the Secretary, Chief Secretary, and the Principal Secretary of the Home Department. All matters required to be decided by the National Capital Civil Service Authority shall be decided and by the majority of the votes of the members present and voting. National Capital Civil Service Authority creates a new statutory authority, National Capital Civil Service Authority, to make recommendation to Lieutenant Governor. Okay. National Capital Civil Service Authority. It creates a new statutory authority, National Capital Civil Service, to make recommendation to the Lieutenant Governor regarding the transfer, posting, vigilance, and other incidental matters. National Capital Civil Service will consist of the Chief Minister of Delhi, who shall be the chairperson of the authority, Chief Secretary, and Principal Secretary of the Home Department. All matters to be decided by the National Capital Civil Service Authority shall be decided by the majority of votes of the member present and voting. Central government will appoint both the Principal Secretary and the Chief Secretary. Powers of the Lieutenant Governor. Lieutenant Governor will act in his sole discretion. It depends the discretionary role of the Lieutenant Governor by giving him the powers to approve the recommendations of the authority or return them for reconsideration. Lieutenant Governor decision will be the final in the case of a difference of opinion between him and authority. Judicial pronouncement related to ordinance. R.C. Kopa vs. Union of India 1920. Upsc Court held that the President decision could be challenged on the ground that the immediate action was not required and the ordinance had been passed primarily. R.C. Cooper vs. Union of India 1970. Upsc Court held that the President decision could be challenged on the ground that the immediate action was not required and the ordinance had been passed primarily to bypass the debate and discussions in the legislature. D.C. Vadava vs. State of Bihar. 1987. Court held that the legislative power of the executive to promulgate ordinance is to be used in the exceptional circumstances. Legislative power of executive to promulgate ordinance, very excellent, and not as a substitute for lawmaking power of the legislature. What are the legislative power of executive to promulgate ordinances to be used in exceptional circumstances, not as a substitute for lawmaking power in the legislature. Now, Krishna Kumar Singh with the State of Bihar 1999 court held that the satisfaction of the President under Article 123 and the Governor Article 213 while issuing an order is not immune from the judicial review. Central government will appoint both the Principal Secretary and the Chief Secretary. Powers of the Lieutenant Governor. Lieutenant Governor will act in his sole discretion. It expands the discretionary role of the LG by giving him powers to approve the recommendations of the authority or return them for reconsideration. Lieutenant Governor decision will be final in the case of the difference of opinion between him and authority. Ordinance making power of the President and the Governor. The ordinance is defined as a law promulgated by the state or the central government without the approval of the legislature. Power to promulgate the ordinance is vested in the Indian Council Act of 1861, Government of India Act 2000, 1901, and Government of India Act 1935. Word ordinance is defined as a law promulgated by the state or the central government without the approval of the legislature. The word ordinance is defined as a law What ordinance is defined as a law promulgated by the state or the central government without the approval of the legislative power to promulgate the ordinance is vested in the Indian Council Act of 1861, Government of India Act of 1999, Government of India Act of 1935. Ordinance is listed in Article 120, the power of President to promulgate ordinance during the recess of the Parliament. Article 2, the power of Governor to promulgate ordinance during the recess of the legislature. These promulgated ordinances have the same force and effect as an act of the legislature, but these acts are like temporary in nature. Ordinance is valid for 6 weeks from the date when the next session starts. With the two houses start their session on different dates, the letter of the dates will be considered issue associated with ordinance making overuse. Formulate laws in emergency situation or when the legislature is not in session. However, it has been overused. Separation of power of executive to make laws goes against the principle of separation of power. Lack of clarity what constitutes emergency situation necessity as a ground to pass the ordinance. To contemplate laws made by the ordinance bypass the legislature scrutiny and the sample the basic function of the Parliament. Ordinance is valid for 6 weeks from the date when the next session is started. If the two houses start their session on different dates, the later on the dates will be considered. Ordinance may lapse earlier if the President and the Governor. These promulgated ordinances have the same force and effect as the act of legislation, but these are like temporary in nature, valid for 6 months. When the next session of the House start the session on different day, the letter on the days will be considered. Ordinance may lapse earlier if the President and Governor withdraws it. If both the houses pass resolution disapproving it. Ordinance can only be issued on matters on which the Parliament or the legislature can make laws and are subject to the same limitation as the Parliament legislature to make laws. However, the Governor of a state cannot make an ordinance without the reference of the President in the following cases. Bills that have similar provision require the prior approval of the President to introduce the bill in Assembly. If the Governor would have deemed it necessary to reserve the bill containing the similar provision for consideration of the President, if an act of a state legislature containing some provision would have been invalid without receiving the President's assent, there is a need to define the term mentioned under Article 133 and 213. 213, that is emergency situation necessity, should be defined clearly to prevent the misuse. Also, executive should exercise self-restraint. Situation necessity should be defined clearly to prevent emergency situation necessity. Also, executive should exercise self-restraint and use ordinance making powers separately as mandated by the Constitution and makers. Model Prison Act. Those are the Ministry of Home Affairs has prepared the Model Prison Act. Those are that will replace the Prison Act of 1894. The Prison Act of 1894, the first legislation that governed the management and administration of the prison in India, was the Prison Act of 1894. The Act has its origin in the recommendation of the Prison Discipline Committee appointed in 1830. Ministry of Home Affairs has prepared the Model Prison Act, which will replace the Prison Act of 1894, the first Model Prison Act 2023, and the will replace the Prison Act of 1894. The first legislation that governed the management and the administration of the prison in India was the Prison Act of 1894. The Act had its origin on the recommendation of the Prison Discipline Committee appointed in 1836 by the Lord Macaulay. The Representation of the People Act of 1951 prohibits anyone confined in a prison from exercising the right to vote. This includes the incarcerated prisoner as well as under trial. Ministry of Home Affairs has prepared the Model Prison Act that will replace the Prison Act of 1894. The first legislation that governs the management and the administration of the prison of India was the Prison Act of 1894. The Act had its origin on the recommendation of the Prison Discipline Committee that was appointed in 1836 by Lord Macaulay. 1836 by Lord Macaulay. It defined a prison as any jail or place used permanently or temporarily for the detention of prisoners, excluding police custody, subsidiary jail. It also laid down the provision for the prisoner's employment, health, and visit. Ministry of Home found various shortcomings in the Act and noticed a significant lack of emphasis on corrective measures. Employment, health, and business. It directed the Bureau of Police Research and Development to review the laws and prepare a new draft which culminated in the Model Act of 2003. What Constitution says? As per the provision of the Constitution, prison and the person detained therein fall under the state list. This means that the responsibility of the prison management and administration solely rests with the state government, and alone is competent to make the appropriate legislative provision in this regard. Thus, the Model Act may serve as a guiding document for the state so that they may benefit from its adoption in the jurisdiction. Okay. Prison and the person detained therein fall under the state. This means that the responsibility of the prison management and administration solely rests with the state government. Need for reforming the colonial hangover. India's incarceration system is prone to abuse since it was set up by the British to subjugate the political prisoners. India's incarceration system is prone to abuse since it was set up by the British to subjugate the political prisoner. The Act permitted whipping, provided that the number of the stripes shall not exceed 30, albeit for only male prisoners. To make prison reformative institution, Prison Act of 1894 focused on keeping criminals in custody and enforcing discipline and order in the prison, leaving no provision for reform and rehabilitation of prisoners. Today, prisons are seen as a very reformative and a correctional institution for better living facilities of the prisoner. There is a need to make the jail modern and technologically adapt with stringent security measures. Also, there is a need to introduce the better living and healthy facilities, libraries, and training program for prisoners to help them get back to society. Killing and violence within prison. There have been incidents of killing and the gang violence within the prison. Example, recent 33-year-old inmate was allegedly stabbed to death by the members of a rival gang inside the Tihar jail. More proposals are included under the Portal Prison Act of 2003 to increase the good conduct provision for the grant of parole, furlough, and remission to the prisoner. Parole, furlough, and remission. Parole is a system of conditional release of the prisoner with the suspension of the sentence for a specified period of time. Conditional suspension of the sentence for a specified period of time. Furlough is given in cases of long-term imprisonment. The period of furlough granted to a prisoner is treated as a remission reduction of his sentence. Furlough is given in cases of long-term imprisonment. The period of furlough granted to a prisoner is treated as remission. Furlough is given in cases of long-term imprisonment. The period of furlough granted to a prisoner is treated. Furlough is given in cases of long-term imprisonment. The period of furlough granted to a prisoner is treated as remission reduction of his sentence. Furlough is given in case of a long-term imprisonment. The period of furlough granted to a prisoner is treated as a remission reduction of his sentence. Furlough is given in case of long-term imprisonment. The period of furlough granted to a prisoner is treated. The period of furlough granted to a prisoner is treated as remission reduction of his sentence. Bail means procurement of release from the prison of a person awaiting trial or an appeal for reformation and the rehabilitation. Bring about the attitudinal change toward the prisoner. Vocational training and the skill development. Bring about attitudinal change toward prisoners. Reformation and the rehabilitation. It brings about the attitudinal change toward the prisoners. Reformation, rehabilitation, attitudinal change toward the prisoners, vocational training, skill development for better safety, security, separate accommodation for the women and transgender inmate, use of technology in prison administration, establishing high security jails, use of technology in prison administration, separate accommodation for the women and transgender inmate, use of technology in prison administration, establishing high for reformation and rehabilitation. Bring about attitudinal change toward the prisoners, vocational training, skill development, separate accommodation for women transgender, use of technology in prison administration, establishing high security jail, provision for open and for an open, semi-open jails have also been certain measures for prisoners to video conference with courts have also been introduced along with the Prison Act of 1894, Prison Act 1990 and the Transfer of the Prisoners Act 1950 have also been reviewed and their relevant provisions have been assimilated into the Model Act. Okay, other issues faced by the prison. High and trial. Prison Statistics of India 2021 showed that more than 77% of the jail inmates are under trial. The same data sets also records 25% of this prisoners' population as being illiterate. 77% and under trial, 25% illiterate. High occupancy rate of the prison. As per the National Crime Record Bureau 2021 statistics, there was a total of 5,54,000 people in prison across the India as against a capacity of only 4,25,000. Prison really had a occupancy rate of 183%. Difficulty in obtaining bail, delay in adjudication process, lack of support for filling of bail application or any delay in education process, lack of support for filling of bail application, and ability to comply with bail condition. The bail system further leads to prolonged incarceration. In this context, Supreme Court directed the Union Government to consider introducing a separate bail act to streamline the process of granting bail. Vacancies in prison officers in Uttarakhand, Chhattisgarh, Bihar, and Jharkhand, over 60% of other office prisoners were vacant. 60% of officers' positions were vacant. This increased burden on officers and also leads to poor management of the prison, including the crime within the prison. Unnatural death in the prison. According to the Prison Statistics of India 2000, there was 185 unnatural death of inmate in 2000, 150 inmate. Unnatural death. 185 unnatural deaths. Suggestion to reform prison. Supreme Court has announced 3 broad principles regarding the imprisonment and custody which shall be followed. First, a person in prison does not become a non-person. Second, a person in prison is entitled to all human rights with the limitation of the imprisonment. Third, there is no justification for aggravating the suffering already inherent in the process of incarceration. Easier bail process. Section 436 of the Criminal Procedure of Code 436. 436 of the Criminal Procedure Code stipulates that a person having undergone detention for half as much time as the maximum period of imprisonment except in death penalty is entitled to be released on bail with or without sureties. Section 436 of the Criminal Procedure Code stipulates that a person have undergone detention for half as much time as the maximum period of imprisonment except in death penalty. having undergone under detention for as much as time for half as much time as the maximum period for imprisonment except in death penalty is entitled to be released on bail with or without sureties. Faster disposal of bail case in Hussain versus NR versus Union of India 2000, the Appellate Court had ordered expeditious disposal of the bail application along the principle of bail being the norm and jail being the exception. Of bail being the norm, jail being the exception. Bail being the norm, jail being the exception in Hussain. Mullah Committee 1980, the Government of India set up a committee on jail reform under the chairmanship of Justice C.N. Mullah. Some of the prominent recommendations of the Mullah Committee are the prison staff to be properly trained and organized into different categories, setting up an all India service called the Indian Prison and the Correctional Health Service, aftercare, rehabilitation, probation to be an integral part of the prison service. Mullah prison staff is to properly train, organized, setting up an all India service called Indian Prison and Correctional Service, aftercare, rehabilitation and probation. The press and the public to be allowed inside prisons and allied correctional institutions periodically. Under trials in jail to be reduced to bare minimum and they be kept away from the convict. Under trials in jail, bare minimum and kept away from the convict. The press and the public to be allowed inside the press and allied correctional institution periodically. Model Prison Manual 2016. Government in 2017 introduced the Model Prison Manual. It aims at bringing in basic uniformity in laws and regulation governing the administration of the prison and the manual management of prisoners all over the country. However, only 11 state and union territories have adopted the new manual. Open prison. Open prison is penal establishment in which the prisoners serve their sentence with minimal supervision. Open prison is the mechanism in which the prisoners serve their sentence with minimal supervision and perimeter security and are not like the prison cells. Open prison model adopted in Rajasthan has promoted reformative form of punishment and succeeded in transforming the lives of inmates. Open prison is 92% less staff than the closed jail and incur monthly a cost of only rupees 500 per prisoners. Less staff than closed jail and income monthly cost of only 500. Whip. Constitutional bench is if Sena case is ruled as the power to appoint the whip and a leader rests with the judicial, political party or legislature party as stated in the 10th schedule of the Constitution. Key observation of the Supreme Court: appointment of a whip. Speaker must recognize the whip and the leader authorized by the political party based on the party constitution after conducting inquiry. Allowing the legislative wing to act independently from the political party contradicts the constitutional system of governance. Speaker to decide disqualification. Disqualification not to be decided as per the established procedures in law, and the Speaker is the appropriate authority for this under the 10th schedule of the Constitution, which lays down the anti-defection law. Emphasized that the Speaker should decide on pending disqualification petition in a reasonable time frame. Speaker must recognize the whip and leader authorized by the political party based on the party's constitution after conducting an inquiry. Allowing the legislative wing to act independently from the political party contradicts the constitutional system of governance. Speaker to decide disqualification. Disqualification ought to be decided as per the established procedure in law, and the Speaker in the appropriate authority is the appropriate authority for this under the 10th schedule of the Constitution, which lays down anti-defection. Emphasize the Speaker should decide on pending disqualification petition in a responsible time frame. MLA reasonable time frame. Okay. MLAs have the right to participate in proceedings of the House regardless of the pendency of any petition. Right to participate in proceeding of the House regardless of pendency of any petition for disqualification. Floaters. A floaters is to be conducted by the governor only on obtaining the objective material to show that the incumbent governor had lost the confidence of the House. A whip may refer to both a written order to members of a party in the House to abide by a certain direction and to designate it official of the party who is authorized to issue such a direction. All parties can issue a whip to their members. Parties appoint a senior member from among their House intend to issue whip. This member is called a chief whip and he is assisted by the additional whip. Article 142. Supreme Court rules that it can directly grant divorce to couples under Article 142. Supreme Court held that it could directly grant divorce in cases where marriage has irretrievably broken down, dispensing with period prescribed under the Hindu Marriage Act of 1955 as per the Section 13B of the Hindu Marriage Act of 1955. After filing a first motion seeking divorce through the mutual consent, parties have to wait for a minimum of 6 and a maximum of 18 months before moving the second motion. However, Supreme Court stated that the grant of divorce on a ground of irretrievable breakdown of marriage is not a matter of right but a discretion. Irretrievable breakdown of marriage is not a matter of right but a discretion. After as per the Ministry and the Marriage Act, as per Section 13, after filing the first motion seeking divorce through mutual consent, parties have to wait for minimum 6 and a maximum of 18 months before moving the second motion. So Article 142 provides the Supreme Court the power to do complete justice between parties, where at times law or stature may not provide a remedy. While powers under the Article 142 are sweeping in nature, Supreme Court has defined its scope and extent through various judgments. Prem Chand Garg case 1962 demarcated the contours for powers under Article 142. Union Carbide Corporation versus Union of India. Supreme Court in 1991, while highlighting the wide scope of Articles 142, ordered the compensation for the victim. Supreme Court Bar Association versus Union of India 1998 powers under Article Supreme Court Bar Association versus Union of India powers under Article 142 are supplementary and could not be used to supplant or override a substantive law. Supreme nature of his powers are arbitrary and ambiguous. Absence of a standard definition for the term complete justice. Violation of the separation. Okay. Okay. Now Supreme Court what's it? Demarcated contours of power under Article 152. Under Article 152 power, Supreme Court provides Supreme Court power to do complete justice between parties where at times law and statute who may not provide a remedy. While powers under Article 142 are sweeping in nature, Supreme Court defines its scope and extend to various judgments and provides Supreme Court power to do complete justice between parties. Prem Chand Garg case demarcated contours for powers under Article 42 under the Union Carbide Corporation versus Prem Chand Garg in 1962. Union Carbide Corporation was demoted by the Supreme Court in 1991 while highlighting the wide scope of Article 142 order compensation for the victim. Supreme Court Bar Association versus Union of India 1998 powers under the Article 142 are supplementary and could not be used to supplant or override. Powers under Article 142 are supplementary and could not be used to supplant or override a substantial law. Supreme Court nature of these powers are arbitrary, ambiguous, absence of a standard definition for the term complete justice, violation of the separation of power, district judiciary. Supreme Court says that district judiciary independence is part of a basic structure. District judiciary is independent. Supreme Court will make judgment in all India judges with Union of India case filed by certain principles concerning the judiciary, including independence of the district judiciary equals a part of the basic structure of the country as it compounds an important role in upholding the rule of law. Judicial independence and access to justice ensures implementation of the Part 3 of the Constitution. Integration in terms of the pay, pension and other service conditions between district judiciary and High Court and Supreme Court. Separation of power. Officers will judicially be treated separately from the staff of legislative and executive wings. Okay. Uniformity in designation and service condition. Uniform judiciary entails that the service condition of the judges of one state are equivalent to the similar court of judges of other state. As per the court record, in a single day, district judiciary handled nearly 11 case. District judge is higher judicial authority in the district. Organizational structure, jurisdiction, and nomenclature of subordinate judiciary are laid down by state. Hence, they may differ slightly from the court state to state broadly. Organizational structure, jurisdiction and nomenclature, appointment, posting and promotion of the district judge are made by the governors of the state in consultation with the High Court. Appointment, posting, promotion of the district judge are made by the governor of the state in consultation. Appointment, posting and promotion of district judge are made by governor of the state. Organizational structure, jurisdiction and nomenclature. Organizational structure in the jurisdiction nomenclature of under judiciary are laid down by the state, hence they differ slightly from state to state. Appointment are laid organizational structure, jurisdiction and nomenclature of subordinate judiciary are laid down by the state government. Hence posting and the promotion of the district judges are made by the governor of the state in consultation with the High Court. High Court, district and section judge court. एक सिविल एक क्रिमिनल है. सिविल के अंदर सबऑर्डिनेट जज कोर्ट, इसके अंदर चीफ जुडिशियल मजिस्ट्रेट कोर्ट, इसमें मुंसिफ कोर्ट, civil side, subordinate judges court, munsif court, chief judicial magistrate court, judicial magistrate, recusal by the judges. Supreme Court judges refuse to recuse himself from hearing a plea by a former IPS officer whenever there is a potential conflict of interest. A judge can recuse or withdraw from a case to prevent the perception of bias, chief principle, including recusal by judges. Nemo judice in sua causa, that is, no person shall be a judge in his own case. Nemo judice in sua causa. Justice must not only be done but also be seen to be done. Propounded in 1924 in Rex versus Sussex Justice by then Lord Chief Justice of England, India has a no codified rule governing recusal, and the decision to recuse rests solely on the conscience and the discretion of the judge. Solely on the okay, India has no codified rule governing the recusal, and decision to recuse is solely on the conscience and the discretion of the judge. If a judge recuses himself, the case is listed before the Chief Justice for allotment to an alternate. When Supreme Court judgment on the recusal, Ranjit Thakur versus Union of India, 1887, the Supreme Court ruled that the test for determining the likelihood of bias is based on the reasonableness of the apprehension perceived by the party involved. Reasonableness of the apprehension. State of West Bengal versus Sib Nanda Pathak, 1998. Supreme Court defined a judicial bias as a preconceived opinion to decide a case or an issue in a particular kind of recusal. Automatic where a judge himself withdraws from the case when a party raises a plea for recusal, highlighting the possibility of bias or personal interest of the judge in the case. E-governed state. E-governed state. एक second. Kerala has become the first fully governed state in India. It has digitized a range of the government service, ensuring a prompt and transparent delivery to its citizen. Prompt and transparent delivery to e-governance, meaning electronic governance, is using ICT such as media network, the internet, and the mobile health computing for the purpose of enhancing governance. Initiative of Kerala Fiber Optic Network, a project which has made internet access a citizen's right. E-Sevanam, a single portal for 900 public service to taluk level. Kerala Fiber Optic Network project. Kerala Fiber Optic Network project, which has made internet access a citizen's right. E-Sevanam, a single portal for 900 public E7 Kerala Fiber Optic Network project, which has made internet access a citizen's right. E7 a single portal of 900 public service to taluk level. Press freedom in India was ranked 161 out of 180. Norway, Ireland, and Denmark. Norway occupied the top 3 positions. It is based on the Paris-based Reporters Without Borders, one of the world's leading NGOs in defense and promotion of the freedom of information. It is published on the World Press Freedom Day on 10 May. Evolution is done using 5 contextual indicators: political context, legal framework, economic, socio-cultural context, and Internet said the Supreme Court has issued notice seeking the compliance of the government with respect to its judgment in another Vaseem case. In another Vaseem case, the suspension of the mobile landing internet service in the state of the Jammu and Kashmir at the time of the revocation of Article along with the restriction on movement certain areas was challenged in another Vaseem case. Key guidelines proposed in another Vaseem case: in order suspending the internet service definition is impermissible under the temporary suspension of telecom service, public emergency, or public service rule. The suspension can be utilized for a temporary duration or any order suspending the internet issued under the suspension rule must adhere to the principle of proportionality and must not extend beyond necessary duration. Proportionality, not beyond duration. Any order suspending the internet under the suspension is subject to judicial review. The court has also declared that the freedom of the speech and expression, as well as the freedom of trade and commerce, speech, expression, trade, and commerce through internet, are constantly protected by Article 91A and Article 91. The internet shutdown related provision in the country: suspension of telecom service, including internet shutdown, is governed by the temporary suspension of telecom service, public emergency, and public safety rule 2017, notified under the Indian Telegraph Act of 1885. Those are the rules provide for a temporary shutdown of the telecom service in a region on account of a public emergency up to 15 days at once. Rules provide for a temporary shutdown of telecom service in a region on ground of public emergency up to 15 days. Suspension of the telecom service, including internet shutdown, is governed by the temporary suspension of telecom service, public emergency public safety rule 2017, which is notified under the Indian Telegraph of 1885. Those are the rule for temporary shutdown of telecom up to 15 days at once. Narco analysis. Recently, the restless protesters at Delhi have asked for the undergoing narco test, provided it is monitored by the Supreme Court. As part of a narco test, sodium pentothal, also called the truth serum, is injected into a person. If doing this lowers a person's self-consciousness, thereby allowing them to speak without inhibition. This test is performed under the guidance and supervision of a psychologist and investigating officer of forensic. Truth serum, sodium pentothal. Sodium pentothal truth serum. Doing this lowers a person's self-consciousness, thereby allowing. Okay, Supreme Court in Salvi orders versus State of Karnataka and Anna ruled that the narco analysis, brain mapping, and the polygraph test cannot be conducted on any person without his or her consent. The judgment was given taking a view of the fundamental right. Article 23, right against the self-incrimination, and enumerated in the Constitution, state that no person accused of an offence shall be compelled to be a witness against himself or herself. Article 21, which is the right to life and a personal liberty, has been judicially expanded to include the right against the cruel, inhuman, or the degrading treatment. Those who volunteer must have access to and right to cruel, inhuman, and degrading treatment. Those who volunteer must have access to a lawyer and have a physical, emotional, and the legal implications of the test explained to them by the police and the lawyer. Narco-analysis report is not admissible as a primary evidence in the court. However, any information or material that is subsequently discovered with the help of volunteer administered test, the result can be in accordance with the section 27 of the Indian Evidence Act 1872. Polygraph test. A polygraph test is another form of psychological, physiological examination, but in this test, no substances are injected into the person's body. Instead, instrument to measure blood pressure, pulse rate, breathing, sweat gland, and blood flow is attached to the person. After this, she would have to answer some question. Brain mapping test, P300 test, or the brain mapping test involves the mapping of the brain activity rather than physiological behavior. Done in the same manner as the polygraph test, brain mapping may cover aspects of the field of neuroimaging as it produces images of the brain that have been enhanced by the result of the additional imaging or non-imaging data processing or analysis. Thank you so much.